Well, here we are sitting in the conference room at TBHR, Tarlow, Hart, and Rodgers. My name is Jeffrey Davis, and that means this is For the Record, the Radio Entrepreneurs Legal Show, leading legal community of New England. That means to my left, my sidekick, the man who bails me out all the time, Mark Z from Mark Z Legal Staffing. Hi, Mark.
Hey, Jeff. Great to be with you. Honor and very excited.
Thank you, Mark. Our next guest, returning guest, surprising always when an attorney comes back for more, Kenneth DeMoura, partner DeMoura and Smith. But you've got a couple of updates in the law you wanted to talk to us about, right?
Well, yeah, I did, Jeff. Thanks for inviting me back. Good to see you both, Mark, Jeff. The updates, last time I was here, of course, we talked about the new non-compete law that the legislature was considering. And since then, of course, they passed a new non-compete law that all employers ought to be aware of. It does have significant restrictions on who can be subject to a non-compete and the consideration that needs to be given to the employee, including what's known as garden leave consideration, which is payments after the employee leaves the company. So I would really...
Oh, I like that because, a lot of my clients, too many, they go online, they take old documents, they don't consult an attorney, and they're not up to date on the law.
You're right. You're right. In fact, a lot of our a lot of the stuff we do as a litigation firm is come along after the fact when we look back and we say, gee, I wish we could have been there to give that counseling advice as opposed to the advocacy advice and help the client draft an appropriate non-compete or agreement. So yeah, it's a little too late at that point to help, and the idea then is to try to do the best you can to defend the contract.
Now, after these changes came out, were you back in touch with some of your clients to talk about rewriting some of the agreements or some of the changes?
Yeah, we actually sent out a client alert. I did a video. It's about a 5-minute video on our website and on YouTube on the 10 things you need to know about the new non-compete law, and clients did, respond and say, hey, yeah, here's our old agreement. Let's fix it and make it right. And I periodically do updates and let them know that if they haven't done that yet, they really should. And along with that new non-compete law, at the same time, there was the Massachusetts finally adopted a version of the Uniform Trade Secrets Act. So now there is a statutory right, a statutory cause of action if your employees violate a non-disclosure agreement or steal your trade secrets and use them somewhere else. It's got a little more teeth in it than the common law had, and there's a sort of comparative federal statute too that allows you to bring a claim in federal court and recover attorney's fees if you want. So, and we've let our clients know about these developments because. Again, same thing. You have a non-disclosure agreement that you have used for years and years and years. You put it away, and then a new employee starts, and you have that employee sign it, not realizing that there have been changes in the law about the definition of what a trade secret is, for example, and the client ends up not being able to enforce that agreement.
Now, I'll be the troublemaker here. A lot of times, again, in larger firms, what I'll find is that human resources taking responsibility for this, and they're not up to date on the law, that they have to take counsel from attorneys as well. Have you noticed that also?
Well, yeah, and a lot of really good HR departments do.
Right, the good ones do. Right.
Checking in with their employment attorneys and having them do a review of the documents and forms that they're using. The check the box law is another good example, right? Not you can't really ask about a
salary anymore.
A salary issue,
right.
or even a criminal conviction issue,
right?
And companies just aren't some companies that aren't really staying up to date and involved in that are finding themselves getting into trouble.
Right, Ken. Can you also talk about selfishly, this affects my business is the law that came down relating to commissions and wages?
Sure. There was a case actually decided 2 weeks ago, or it was decided on February 12th of this year by the Supreme Judicial Court in Massachusetts involving an interpretation of the failure to pay wages statute in Massachusetts. And the court in this case, called the Parker versus Ennernock case, really spent significant time talking about the failure to pay commission payments to an employee, a sales executive, for example, and the failure to do so even after the employee leaves employment.
Right.
And in this case, the employer took the position that on the day you leave, I only have to pay you what's due and payable on that day, and I fulfill that requirement. And then because our commission policy says that you don't get commissions unless you are still with the company when the commission is earned, you don't qualify for it.
Right.
And the SJC in this case decided that while that may be a well-written commission policy, and again, here we go with are you having your attorneys look at your documents and your policies? A well-written policy could protect an employer from a situation where the commission actually comes in after the fact. In this case, it didn't. And in this case, the facts indicated that the company had allowed employees to earn commissions even after they left the company, even though it wasn't in writing. And because they refused to pay it to this employee after she left.
After they left the company.
Right.
Wow.
And because they didn't pay the
You guys
employee.
are fired.
She wasn't. She left because the way they had interpreted what the payment they had made to her
Right.
already was bad.
Well, can I just say something?
Yeah.
I think from an employer's standpoint, there's got to be a balance. Like it's quantum it. Like if you're working on something, like for example, when I have people leave, I had somebody leave. She wanted to get out of the recruiting business, but she had like 3 deals that she was working on. That even though the people hadn't started yet, they were all deals that she was involved with every step of the way.
Right.
That why shouldn't the person share it? And then obviously you have the rules of in our business with guarantees, and I think they should be protected on that, but there's got to be a balance. Obviously, if the deal goes south or something happens where you have to have money back or something happens, then obviously there's got to be a balance.
Right,
But
and that's the fair. I think you're right. That's an equitable and fair approach. And here, the interesting thing about this commission that she was entitled to, she didn't have to do anything to get this other piece of the commission. So she brought a sale in. The way the policy worked at the company was that she earned an initial commission. If that customer, and the customer signed a long-term contract that they could get out of within a year, if the customer did not get out of it within that year, it would automatically become a 10-year contract, and there would be an income stream.
Oh, now
or
I
commission
understand.
Stream.
Right.
So
she
here-
really made that the big deal for
Yes,
them.
she made
Right.
a huge deal for
Right.
them. And really, the only thing that she had to do was wait and see if they were going to, continue that contract after the first year. And so it's an unfortunate result for this employer because they really got hit with a very, very large judgment against them.
Again, going back to where I started, employers need to seek counsel before they act.
think
Much
you're right.
more today than they did in previous years. And I'll even say, as a management consultant, I don't think I ever consulted an attorney 35 years ago when I started my firm, when I was working as a management consultant. But today, I work in a multidisciplinary team all the time. I'm always asking, who's the attorney? Can I make contact with that attorney right away?
Sure.
And I want to know what I'm doing and what's going on. I want the attorney to know what's going on because it's essential.
It's a minefield. You got to be collaborative. You also have to, as a business person, you've got to use common sense and involve the attorneys in common sense. What is fair? And I think if you practice fairness and you work with your attorney collaboratively, that's going to help as like pay me now or pay me later.
So many times can clients say to me, Jeffrey, do I really have to get an attorney? I go, we're not negotiating this. Get the attorney.
Well, do you remember the Fram commercial? Pay me now or pay me later?
Right.
The driver that never gets his oil changed.
Right.
Because,
Right.
it's going to cost me a couple bucks to do it. And then later the engine seizes, right?
Right.
So here it's the same thing. And I think, to your point, Mark, companies and owners of companies also need to think sort of predictively. Okay, how is this going to play out? Maybe today I need a document. I'm going to go on Google. I'm going to find it. I'm going to get them to sign it, without really looking through and what are the consequences of each of the terms. Choice of law provision, for example, is a big. We're fighting a case right now about whether New Hampshire law should apply or Massachusetts law should apply, and the other side, candidly, didn't even think about that when they were negotiating the contract, but there were significant differences between how the contract needed to be performed in Massachusetts versus in New Hampshire.
Very important subjects for you, because this is what you do, but also for employers. They need
Thank
to
you,
be
Ray.
much more aware. We hope we tag this so that they know that they've seen this. We've been speaking with Ken DeMoura, partner DeMoura and Smith. Ken, if somebody wants to find you, how would they do that? At
well,
work.
I'm sorry? At work, right, yeah, at work. So we have a downtown Boston office, but we just opened an office in Wakefield, Massachusetts as well.
Excellent. Congratulations.
We've found that a lot of our clients now like the convenience of being able to park for free and not have to drive into the city. So
You got me out of Boston.
yeah, that's right. And my email is kdemora@demorasmith.com, and our phone number is 617-535-7531.
That's great. And we're sure we're going to see you again in the year 2000. And thank you to Mark Z from Mark Z Legal Staffing. Mark, if anybody wants to get hold of you, I know you're already working with all the best law firms in Boston. How would they find you?
First of all, 617-338-1300, markzlegal.com, marczlegal.com, or just Google MARCZ, we come up. But the other thing, Jeff, is 2000's going.
Yeah.
We're in the 2020, and looking forward to an amazing decade ahead.
Decade. Oy. Well, let's take a break on that. And we'll be right back with more stories on Radio Entrepreneurs.